So welcome to our Hey Legal exclusive. This afternoon I am joined by Lord Ericht. So good afternoon, Lord Ericht.
Good afternoon, Edith.
Very nice to have you with us. And we are going to be talking predominantly this afternoon about the recent poll that was run by the Scottish Council of Law Reporting in relation to cases, and you obviously picked out a couple of cases, and we hope to talk about them this afternoon. So thank you very much for agreeing to join us, and I'm really excited to hear what you have to say.
Well, it's a pleasure to be here, so thank you very much for inviting me.
Not at all. So we'll just start then with the first question. And Donoghue against Stevenson and Moorov, you have spoken of these cases as being grounded in vivid, down-to-earth, easy to understand stories, and grappling with issues which humanity has grappled for millennia. I wonder if you could expand, please, on your thoughts as to the reasons for these cases being of such importance and enduring relevance.
Yes, certainly. The reason that these cases were brought to mind was that the Scottish Council for Law Reporting, which publishes session cases, had organised a poll to celebrate its bicentenary. So out of the 200 years of session cases, people were invited to vote for their top case, and people voted from all over the world: Australia, India, America, Scotland, and eventually we got the top 10 published by the Scottish Council of Law Reporting. And the top two were at number 1, Donoghue against Stevenson, and at number 2, Moorov. And that got me thinking, actually, given that these were number 1 and number 2, just what are the similarities and connections between these two very popular and very important cases. And the first thing that I hadn't really thought about until I started looking into it was it's quite interesting that they are decided at around the same time, because Moorov and the Inner House in Donoghue and Stevenson were both in 1930. And in fact, some of the same judges were in both. So that's one point of connection between numbers 1 and number 2. Another connection is that they're not technical. They're not technical lawyer's law full of difficult arguments and concepts. They are really grounded in very simple stories, the kind of stories which we can all relate to and are part of everyone's lives, whether they're a lawyer or not. Donoghue against Stevenson, that's all about two people going out to a cafe, going out for a nice drink with friends. Now, I'm sure over lockdown, many people have been dreaming of the ability to do that, which just shows how universal that idea and experience is. A few years ago, Scottish Council of Law Reporting produced a video about Donoghue against Stevenson, and it's all reenacted, and you can see actors playing them, going to the cafe. But if you take away the 1930s costumes and the 1930s hats, then it could be any one of us or any member of the public just going out to having a nice outing with a friend. Moorov as well, less pleasant in a way, but I think that the Me Too movement has just brought to everyone's attention just how prevalent sexual abuse in the workplace is. And so the situation we have in Moorov, where we have an employer who is abusing a series of employees, is not actually an issue which is remote and can't be understood by the normal person in the street, which is very unfortunate, but that's the way it is. So when you think about it a bit more, why are these cases interesting? I do think they're grounded in that daily life of everyone, as I've said, but they're also grounded in the human condition, and they're grounded in things which have been troubling people for millenia. If you take Donoghue against Stevenson, the famous formulation by Lord Atkin poses the question, who is my neighbour? And that's a direct lift from the New Testament, the question Jesus puts in connection with the parable of the Samaritan. And so in that situation, you can see that although the courts were grappling with it in 1930, it had been grappled with as a moral issue for thousands of years before that. The reasoning in Moorov, although sometimes we can think of Moorov as quite a relatively recent case, a 1930s case. Well, it's a long time ago now, but in the whole scale of things, relatively recent. But actually, it can be traced back through time, and the reasoning can be traced back through medieval times in the canon lawyers, right back to a trial which is said to have taken place in about 650 BC. So the Moorov reasoning recognizes some elements of the internal human condition, if you like. It recognizes that there's an age-old problem that sexual offences are usually committed in private. It also recognizes there's an age-old problem, an age-old truth, that sexual offences are often not a one-off, but they're part of a series, part of a course of conduct. And if you go back to medieval times, the canon lawyers on which our modern law is based, they knew that. And they drew a distinction, for example, between a one-off offence. So the example they took was a one-off offence, like if you murdered a bishop. If you murdered a bishop, that was one act. So you needed two witnesses to that one act. Mm-hmm. They distinguished that from adultery. And when you look at adultery, that is generally a series of acts rather than just a one-off act. So the canon lawyers said, well, actually, you just need one witness to each individual act of adultery. So you can have separate witnesses to separate acts, but then you have corroboration, as we would say in the modern sense, of the whole code of conduct. So that's in the concept of adultery rather than sexual offences, but any criminal lawyer will recognise that the reasoning is exactly the same. Mm-hmm. So the medieval canon lawyers got there by thinking about a lady called Susana. And Susana should be appearing on the screen, so you can see the photograph of an oil painting of her. And the story of Susana resonates through the ages. She's been painted by just so many people. She's been painted by Rubens, Van Dyck, Tintoretto. She's even been painted by Picasso, bringing it right up to date. Now, the pictures on screen is actually by Artemisia, who is a female artist. And I think it's particularly interesting to have this picture. Artemisia was largely forgotten and her work wasn't recognized, I think, largely because she was a female. But some of you may be aware that just last year, the National Galleries in London had a big exhibition of her work, and she's now being recognized for the fantastic artist that she was. And the other interesting thing about Artemisia was that, as well as being a woman, which might give her a natural sympathy for Susana, as you can see Susana in this picture, Artemisia was also a rape survivor, and she was raped at an early stage, and when she was just a teenager, and the matter went to trial, and there was a conviction. And if we think that it can be traumatic for rape complainers to give evidence in the Scottish courts, and we bring forward all the safeguards and special measures that we have to make it as untraumatic as possible, I think it must have been even more traumatic for her, because instead of cross-examining the complainer in those days, what they did for her was they tortured her to see if she was telling the truth. And after they tortured her, they decided she was telling the truth, and she convicted and the court convicted the person who had raped her. So change days. Anyway, Susana, the story of Susana is to be found in some old Jewish texts. It's found in the Catholic version of the Bible. It's not found in the Protestant version of the Bible. It's not in the Jewish version of the Bible, but it is in, interestingly enough, the 1001 Nights, the Arabian Nights, along with Sinbad the Sailor and Ali Baba and the 40 Thieves. So it obviously had a broad cultural resonance in the past. And so you'll see from the picture that there we have Susana, and Susana is a married woman. And the two guys at the top, they're usually called the elders, and they rather fancy Susana. And so and they get very annoyed because she rebuffs their advances because she's a happily married woman. So they decide to get their revenge, and they go to the court and accuse her of committing adultery with a third party. And what happens then is that there's obviously a sufficiency in modern legal terms because you've got two witnesses to this adultery. But the judge, who happens to be Daniel, as in Daniel in the Lion's Den, just to put this in the whole context, we're talking about a story which is the Jewish exile to Babylon, which is about 650 BC. So Daniel decides that what he's going to do is to take the evidence of the two elders individually. And when he does that, he finds there's some inconsistencies between them, largely because they're lying and they haven't managed to get their stories straight. Does this sound familiar in terms of Scottish criminal trials? And so the inconsistency is they both say that they saw that they were together, committing adultery, and it was underneath a tree. That's all fine. But then when they have to describe the tree, one describes a big tree and one describes a little tree. So there's inconsistency, and she's acquitted. So that's fine. The canon lawyers thought about this a lot, and then they began to think, what if this, and what if that, and what if the next thing? And then they thought, well, what if instead of the two elders having been together and seen this and described an act with two inconsistent trees, what if they hadn't been together and one had come to court and described an act under one tree and another had described an act under another tree? Would that be sufficient evidence? And after a lot of thought, they worked all this through and they followed the logic and they reached what we now call Moorov.
Well, that is incredibly interesting. And thank you for that. And now I can clearly see why you described those two cases in that way, Lord Ericht. That's an incredible walkthrough of both cases and indeed historic law and perhaps how we reach our own current law and how it applies. So thank you very much for that. So other than those two cases that you've mentioned, what or which of the other top 10 cases do you consider of particular importance and why?
Well, I'm not going to talk a lot about these cases, and the reason instead I'm going to really recommend that you go to the Scottish Council of Law Reporting website, because there you'll find what I think of as a little jewel box. Because if you go to the page about this, you will find that there are short articles by a number of judges and lawyers with their thoughts on these cases, and they're just so worth reading. They're very short and they're like perfect little jewels explaining the case and what the significance is, and they're all terribly interesting. So I would recommend that people do that, but I'm just going to run through the cases so that you can see what they were. So Donoghue against Stevenson, number 1.
Mm-hmm.
Number 2 was Moorov. Number 3 and 4 were public law. So we have McCormick against the Lord Advocate, which everyone will remember from the university days. And then we have the Cherry case, which is the well-known prorogation case. And it's particularly interesting that that comes in as number 4, because Joanna Cherry was, when she was at the bar, she was one of the members of the Scottish Council of Law Reporting responsible for publishing session cases. So it's rather pleasing that her own case now appears in them and is that popular.
Mm-hmm.
The next one, number 5, is Will's Trustees against Cairngorm Canoeing and Sailing School. And that's a really interesting case about the clash between old-fashioned kinds of recreation in a river, which was fishing, mm-hmm. and the property rights of fishing, and the modern ways you exercise recreation of a river by canoeing down it. So Lord Tyre's written a great little jewel about that, and also refers to, which I hadn't realized, that someone actually has written a poem about the case. So I'm sure, I've not managed to read it yet, but I'm sure it'll be absolutely fascinating to read a poem about a Scottish case report. Mm. Next one in the line is Stewart against Robertson, and that is a case Lord Woolman's written a great little jewel about that, and that is a Victorian love story about an officer. I was going to say an officer and a gentleman, but I'm not quite sure he counts as a gentleman after if you read the whole story. And he falls in love with the daughter of his landlord, and it all ends badly. And as Lord Woolman says, it would provide the engine for a great Victorian novel. So that's worth reading. Mm-hmm. Number 7 is the Duke of Argyll against the Duchess of Argyll, which is a scandalous 1960s society divorce. And then number 8 is Moncrieff against Jimison, which is about servitudes of parking. And then number 9, Scott and Sons against Delsell, not such a well-known case, but there's a great little commentary on it by Jackie McCrae, where she draws your attention to an analogy which one of the judges makes when he's deciding what the result of the case should be. And the analogy involves a tiger escaping from a circus, a traveling menagerie, and preventing a milkmaid from delivering milk. So it's worth reading it for that alone. And then the 10th and last, a very important case, is AXA General Insurance, which really sets out the limits of the power of the Scottish Parliament. So that's a really important modern constitutional case. So you'll see huge amount of variety, all sorts of law in the top 10. All of life was there. Wow.
Well, I'm sure those watching will head over to that resource, and you've made it sound very attractive, Lord Ericht, and I'm sure particularly the people that are summarising or talking about the cases is a great attraction as well. So I'm sure that will be well utilised. So thank you for drawing that to our attention. So my next question is that you yourself were editor of session cases between 2000 and 2016. Which case, opinion, or passage from a case covered in session cases, or indeed from any other jurisdiction, would you recommend that all lawyers should read?
Well, it's a case about an old Act of the Scottish Parliament. And the Act of the Parliament is an Act of 1457. And that Act bans the playing of golf and football because it's interfering with the archery practice, which the people are supposed to be doing in case they get called up to join the army and protect the country. Mm-hmm. But although it's about a Scottish Act, it's actually not a Scottish case, so you won't find it in session cases. It's a decision of the Supreme Court of the United States of America. and it's quite a recent case. It's in 2001. So I'll tell you about it, and then I'm just going to read a couple of passages, if you'll indulge me. The case is called PGA Tour against Martin. Mr. Martin was a professional golfer, and he had a disability, which meant he couldn't walk. And so what he wanted to do was participate in professional golf tournaments, but use a golf buggy. And the American Professional Golfers Association wouldn't allow him to do that, because they said that the walking between the shots was part of the game. It took into account fitness, physical fatigue. It wasn't just a case of sitting down and then occasionally hitting a golf shot. So it came in front of the American Supreme Court, and they decided that they would find in favor of Mr. Martin, because there should be what we would call reasonable adjustments made under the Americans with Disabilities Act. So that's the case. The reason I really think everyone should read it is not the decision of the majority, but it's this decision of the minority. The minority dissenting judgment was given by Justice Scalia, and he really went to town, and he really tore strips off the majority. And I just want to read you some of the parts of his opinion. We justices must confront what is indeed an awesome responsibility. It has been rendered the solemn duty of the Supreme Court of the United States, laid upon it by Congress in pursuance of the federal government's power to regulate commerce with foreign nations and among the several states, to decide what is golf. I'm sure that the framers of the Constitution, aware of the 1457 edict of King James II of Scotland, prohibiting golf because it interfered with the practice of archery, fully expected that sooner or later, the paths of golf and government, the law and the links, would once again cross, and that the judges of this august court would someday have to wrestle with that age-old jurisprudential question for which their years of study in the law have so well prepared them. Is someone riding around a golf course from shot to shot really a golfer? The answer, we learn, is yes. The court ultimately concludes, and it will henceforth be the law of the land, that walking is not a fundamental aspect of golf. Isn't that terrific? Our judges don't talk like that in their opinions. And it doesn't stop there. It goes on to absolutely tear strips off the majority. And I'll just give you one more example. And the majority has a very earnest discussion about the role of luck in golf. So you might be unlucky if the weather suddenly turns bad, or you might be lucky if you get a lucky bounce. And Scalia's riposte is, I guess that is why those who follow professional golfing consider Jack Nicklaus the luckiest golfer of all time, only to be challenged of late by the phenomenal luck of Tiger Woods. And it goes on and on in that vein. So it's just absolutely fantastic and well worth a read.
Oh, wow. That sounds amazing. Perhaps you should have read those out with an American drawl, Lord Ericht.
Yes.
Make them even more authentic. But yeah, that's a very appealing sounding case. And as you say, the minority wins out, which is, in that case, definitely the right decision. All right. So in today's world, in the digital age that we live in, we have live feeds of hearings now, live tweeting by legal commentators, and possibly greater interest in the law than there's ever been. How do you view these developments, and how would you say that session cases have adapted?
Well, I'm sitting speaking to you in front of a big row of session cases, but that's not the way most people read session cases these days. We've had 200 years of leather-bound volumes, and they're still produced. But more and more people, particularly since the pandemic, have been reading the online versions on their computers, and they've been reading them anywhere where they have internet access, and not just in a library or a study or a court. So session cases over these 200 years has always been at the forefront of innovation to keep the service of law reporting up to date. And the current editor is Emma Toner, and she's doing an absolutely excellent job. And she's also pushing that innovation forward. So she now has organized that if there is a really important case, the Cherry case is a good example, then she can arrange for a reporter to be in court, and the reporter will produce a daily summary of the argument and tweet it. And I think that's just a tremendous innovation, because it brings us right up to date with the technology. But also, I think what's very important is that what is being tweeted is very authoritative, and it's very accurate and reliable. And also it's very comprehensive, because I think more and more in court reporting, we see that the reporting is of selective sound bites. So it's really very valuable that tweets are not limited to short amounts, but can give you an up-to-date and comprehensive view of what happened in court that day. And that use of the reporters to go in and tweet, I think really points up one of the most important things about session cases, which has stood it in good stead over 200 years, is really the expertise of the people doing the reporting, because the reporters and the editor are all people who are in practice in the courts in which they're reporting. So they are used to arguing cases in the court and also reporting cases in the court. And I think that gives them a real edge in understanding and producing a good case report. So it's that expertise that they have, which I think puts session cases, when it's combined with a kind of innovation and the kind of innovations which Emma's also introducing, I think that really puts session cases in a very good position to go forward for the next 200 years.
That's fantastic, and really interesting to hear that development. And as you say, sitting there with those amazing books behind you, yet such a great technological advancement in just being able to bring it right up to current times. So yeah, yep. Thank you for enlightening us on that. My next question is, Lord Ericht, what is your favourite quote?
My favourite quote, well, it's Jane Austen, and it's Emma, but it's not the original version. It's Jane Austen's Emma, updated to 1990s Beverly Hills, which is the film Clueless.
All right.
And if you know the film, you'll know the main character is a teenage girl. And this is the quote. This is what she says. "Daddy's a litigator. These are the scariest kind of lawyer. And Daddy's so good, he gets $500 an hour to fight with people. But he fights with me for free because I'm his daughter."
Oh dear, I'm sure many a person can recognise that quote.
Indeed.
Oh, that's very good. Yeah, I am familiar with that film. And, an interesting choice of quote, but thank you for that, Lord Ericht. So we at Hey Legal are involved in an initiative to launch legal careers in Scotland. What advice would you give to lawyers who are just starting out in their careers?
Well, I'm absolutely delighted to hear you're involved in such an initiative, because it's such an important thing. And I've been well aware of that. There was a while in the past I was clerk of faculty, and I was quite involved heavily in encouraging legal careers. And at the moment I'm trustee of the Law Scout Foundation, which is doing tremendous work in helping people who've had really very unfortunate circumstances in their school years to get through that, and it's working really well. And these people who've been supported by the Law Scout Foundation are heading to be really excellent lawyers. So what advice would I give? Two things. First of all, that legal careers are open to all, regardless of your background. I went to my local state comprehensive school in Perth. It's not your background that counts, it's your ability and your hard work. The second thing is that there are just so many different kinds of lawyers. There are standing up lawyers, by which I mean people who appear in court, like advocates, solicitor advocates, court solicitors in the Sheriff Court. And there are sitting down lawyers, by which I mean lawyers who do chamber work, conveyancers, property lawyers, private client lawyers, corporate lawyers, government lawyers, in-house lawyers. There is a kind of law for everyone, and there's a kind of law for every personality. So what I would say to people is, be true to yourself and find the kind of law that suits you and suits you, your personality the best. There's no better job than a job that you love doing.
That is sound advice and very good advice. And yes, it's difficult. I think even more so now. I remember it would have been difficult when I first qualified or first came out of university or out of my diploma, but it seems to be increasingly difficult. So advice like that and initiatives like ours hopefully will stand people in good stead. So thank you very much for that advice. I'm sure people will take that on board. So the final question I have for you, if I may, is what questions should we have asked you?
Gosh, that's a tricky one, isn't it? Well, there's a question that I get asked quite a lot, which is why I'm called Lord Ericht. So perhaps I could just answer that. My surname is Stewart, and normally these days judges take their own surname as their title. But when I was appointed to the bench, there was already a Lord Stewart, so I had to take a different title. And I chose Ericht, which is the name of a little river. It's just a very short river. It runs for about 10 miles from the bottom of Glen Shee through to Blairgowrie. And it's a part of the country where I have a lot of family connections, and my family comes from there. So that's the reason I chose it. But there's another thing. I find I'm quite fascinated by the connection between my job as a judge and rivers, because the river Ericht, the word Ericht is a Gaelic name, but the derivation of the Gaelic is from place of justice. So the river Ericht means the river of the place of justice. So there must at some point, far beyond written memory and even the memory of people, there must have been some sort of court or judge dispensing justice at that river. And yeah, there's other connections as well. There's a quote that Martin Luther King used in a lot of his speeches, which is, "Let justice roll down like a river." So there's another connection between rivers and justice. So all in all, with a name like that, I've certainly got a lot to live up to.
How appropriate for all those connections. But yes, and that's very appropriate, as you're saying, your family connection and also the connection with the justice and river. So thank you so much for sharing that with us as well. And thank you for answering all of my questions. I've now completed all the questions that I had for you. I'm sure there are many, many more. But I'm equally sure that people will have thoroughly enjoyed your answers and the insight you've given. So thank you very much indeed, Lord Ericht, for giving of your time and your knowledge and your stories to us today. Thank you.
Well, thank you for having me. It's been absolutely delightful.
Not at all. All right, thank you very much.